Hi everyone, and welcome back to the channel. I'm Jay, the Principal Migration Lawyer at Flow Migration Law. The Australian partner visa journey is built on a story of love and commitment. But what happens when your story runs into a hard rule? A rule that seems to put a full stop on your future together in Australia. One of the most daunting rules is the partner visa sponsorship limitation. It can make you feel like your journey is over before it's even really begun. Today, I'm going to share the real story of a couple who faced this exact challenge. The Australian sponsor had already sponsored 2 previous partners, putting him at his lifetime limit. Their story is a powerful example of how even an impossible looking barrier can be overcome with a tailored and thoughtful approach. Just a quick reminder, the information today is for general guidance. Immigration law is complex and changes, so it's always best to get advice based on your personal situation. So our story begins in Brisbane. We have an Australian citizen, a dedicated IT professional, who met his partner while they were both studying for their master's degree in IT. She was an international student on a student visa. What started as a friendship grew into a serious, committed relationship. They built a life and home together, and after several years, applying for an onshore partner visa was the natural next step. But during our first consultation, the major problem became very clear. The Australian sponsor, when he was much younger in his early 20s, had already sponsored 2 previous partners. This placed them directly in front of a huge legislative barrier. The rule is clear. You can sponsor a maximum of 2 partners in your lifetime. He was at his limit. The only way forward was to seek a waiver. Now, the law allows for this limit to be waived if you can show compelling and compassionate circumstances. But the common examples the department often points to are quite specific. Things like the couple had a dependent child together, or the sponsor's previous partner has passed away. This couple's situation didn't neatly fit into any of these boxes. They had no children. The previous relationships hadn't ended under those specific circumstances. On the surface, it really looked like they had run out of options, and that's when they reached out to us for help. We knew a standard approach just wouldn't work here. We couldn't just tick a box. We had to build a case that painted a complete, holistic picture of their unique situation, arguing that the sum of their circumstances was undeniably compelling. First, we emphasized the long-standing nature of their relationship. By then, they had been living together as a de facto couple for over 3 years. We documented this evolution from her student visa to her graduate visa, showing how their commitment had solidified over a long period. Second, we demonstrated the 4 pillars in overwhelming detail. We went deep, providing evidence of their intertwined lives, joint bank accounts, a joint lease, and detailed statements from a wide circle of friends and family who had seen their relationships grow over time. Third, we highlighted their significant contributions to Australia. Both were highly skilled IT professionals. We argued that a refusal with me in Australia could lose 2 valuable members of its skilled workforce, especially as she held a master's degree from an Australian university. And finally, we addressed the sponsor's past sensitively. We framed the previous sponsorships not as a pattern, but as decisions made in his youth. We contrasted that with the maturity, stability, and deep-seated commitment of his current, long-standing relationship. This created a narrative of personal growth. By presenting this comprehensive and strategically structured case, we successfully argued that their circumstances, when viewed together, were indeed compelling and compassionate. The department accepted our submissions, and the partner visa was granted. The key takeaway here is that sponsorship limits are not always an absolute bar, and the term compelling and compassionate is a broad concept. It's about painting a complete picture of your unique situation, and sometimes that means thinking outside the box. Navigating a complex issue like a sponsorship limitation requires careful planning and a thorough understanding of the law. As the principal lawyer here at Flow Migration Law, I draw on over 8 years of dedicated experience in Australian migration law. My focus is on ensuring every application story is told in the most compelling and accurate way. If you're preparing a partner visa and you want to ensure it's built on a strong foundation, please contact us for a free 20-minute discovery call. But if you're facing a complex issue like a sponsorship limitation, I encourage you to reach out to me directly by emailing me at js@flowmigrationlaw.com.au to book a detailed consultation. If you found this video helpful, please give it a thumbs up and subscribe. Thanks for watching, and I'll see you next time.